thank you for attending to the RBKC's Licensing Subcommittee virtual meeting. I'm Councillor Soph McVeigh and I'll be chairing this meeting. It's being held via Microsoft Teams and it's also being streamed live, and a record will be kept online. The committee for this hearing consists of myself and Councillor Wason and Councillor Rossi. Councillors, would you please like to introduce yourself and turn your cameras on? Thank you.
Good morning, I'm Councillor Wason.
Good morning, I'm Councillor Rossi from Redcliffe Ward.
Welcome, thank you. And we're joined remotely by Paul Phelan from the Council's licensing team, and our legal officer today is Lindsay Le Mesurier. And also with us, our committee officers is Leonie Hill, who'll be monitoring all the connection and technical issues, and she's supported by Anne and Yasmin. And we will not be using the chat facility, so if you have anything you wish to say, please press the raise hand function would be the best way, please. Thank you. And just a few more ground rules. Please keep your microphones on mute until you're invited to speak, and do turn your camera on if you would like to, but of course you don't have to. And if possible, when you're speaking, make sure your mobile phones are on silent. And everyone should have received the procedure for this meeting before. And if you do lose connection, the details about how to get back in. If for any reason I lose connection, we're going to nominate a substitute chair so the hearing can continue. And I would just like to nominate Councillor Rossi. So if Councillor Wason could second that, that would be great. Thank you.
I will second that.
Thank you. So that's confirmed. Councillor Rossi will be the substitute chair if we need that. And the case before us today is to grant 2 shadow licenses for the Ivy Chelsea at 197 Kings Road and the Ivy Chelsea at 199 Kings Road. We will consider both in the round together, but of course the decision will be 2 separate decisions. And now to declarations of interest. I can confirm that I have no declaration of interest to make. Councillor Rossi?
No declaration to make, thank you.
Thank you. Councillor Wesson?
I have no declarations to make.
Fantastic. Thank you. And just very briefly before we get going, I will outline the procedure. This has again also been circulated with the papers and is online. First, the licensing officer, Mr. Paul Phelan, will give a brief outline of the application. Please, can you confirm your attendance today?
Present, Chair.
Thank you. Then I will ask the applicant's legal advisor, Mr. James Rankin, to present his submission. He'll have up to a maximum of 10 minutes, and he's joined by his instructing solicitor, Mr. Thomas O'Malin, and his client, Brooke Stotesbury. So please, can you all 3 confirm your attendance? Thank you.
Councillor, I confirm my attendance. It's Thomas O'Malin here.
Thank you. Mr. Rankin?
Sorry, yes, I'm here, and I know that Mr. Stotesbury is here as well.
Welcome, thank you. Mr. Brookley, fantastic, thank you. And then after you've presented your cases, then the committee will ask you questions, and then the objectors will ask questions, and also if any of the licensing team wish to ask you questions, they can as well. And then the objectors will present their objections. We have Mr. Williams and Miss Partridge. Can you please confirm your attendance, please?
It's Miss Williams and I'm here.
Thank you. Welcome.
This is Susie Partridge. I'm here.
Thank you. And you will again have a maximum up to 10 minutes each to present your submission, and then questions will be asked by the committee, and then the applicants will ask you questions as well. Finally, after this, we'll ask our legal officer, Lindsay Le Mesurier, to deal with any questions she may have, for example, regarding any conditions. Lindsay, can you please confirm your attendance?
I'm here, Chairman.
Thank you. And then we will turn to the licensing team and the governance team to see if any issues have been raised that we need to cover. And just to remind everyone, there'll be no summing up and the meeting will end. So just before we start, the committee has, of course, read all the papers, so there's no need to repeat the content, but please do draw our attention to specific points. And then as you see on the screen here, I believe it's Paul or Laura will be controlling it, and they can move the document on the screen for us to see. Thank you. So let's get going. Mr. Phelan, please can you outline the case for us? Thank you.
Thank you, Chair. Good morning. There are two applications for the grant of a shadow premises licence before you today. Both licences are in the name of Martin's Mews Limited. The first application relates to the Ivy Chelsea, 197 Kings Road, London, SW3 5ED, and the second relates to the Ivy Chelsea Garden, 199 Kings Road, London, SW3 5ED. These applications seek to mirror the licences currently in operation at the above addresses. A copy of the premises licences currently in operation are attached at Appendix A, pages 7 to 14 of the committee papers for 197 Kings Road, and pages 6 to 13 for 199 Kings Road. If you can now turn to page 2 of the committee papers for the Ivy Chelsea, 197 Kings Road. The following is a summary of the times and the activities sought. The sale by retail of alcohol, both on and off the premises, and the playing of recorded music indoors from 11 a.m. until midnight Monday to Sunday. The provision of late night refreshment indoors from 11 p.m. until midnight Monday to Sunday. Regulated entertainment for private use indoors, unrestricted. The hours of premises are open to the public are from 10 a.m. until 30 minutes past midnight, Monday to Sunday. This application also includes a non-standard timing, which reads from the end of permitted hours on New Year's Eve to the start of permitted hours on New Year's Day. A list of proposed conditions specific to this application can be found at Appendix A at pages 12 to 13. 5 representations have been received opposing the application for 197 Kings Road. A summary of these objections can be found on pages 3 to 4 of the committee report, with copies included at Appendix D, pages 27 to 33. 1 representation has also been received in support of the premises. A summary of this representation can be found at page 4, with a copy of the representation found at Appendix E on page 34. If I can now move to the second shadow licence application. Please could you turn to page 2 of the committee papers for the Ivy Chelsea Garden, 199 Kings Road. The following is a summary of the times and activities sought. The sale by retail of alcohol, both on and off the premises, from 11 a.m. until midnight, Monday to Sunday. The provision of late night refreshment indoors from 11 p.m. until midnight, Monday to Sunday. Hours of premises are open to the public from 10 a.m. until 30 minutes past midnight, Monday to Sunday. A list of the proposed conditions specific to this application can be found at Appendix A at pages 10 to 12. 7 representations have been received opposing this application. A summary of these objections can be found on pages 2 to 4 of the committee report, with copies included at Appendix D, pages 25 to 33. 1 representation has also been received in support of the premises. A summary of this representation can be found at page 4, with a copy found at page E on page 34. No representations have been received from responsible authorities in respect of either application. That concludes a summary of these applications. I'll leave it there for now, unless there is anything else I can be with help at this stage.
Thank you, Mr. Phelan. That was very helpful. Now we turn to the applicant's case, please. Mr. Rankin, can you please present your submission? You've up to 10 minutes, and if possible, please turn on your camera. Thank you so much.
Thank you, Chair. And good morning to you and members of the committee. Thankfully, this is one of those cases where I don't need 10 minutes to make my representations. Thank you very much also for taking both applications together. You're familiar with the concept of a shadow license, having you personally dealt with, Madam, the case concerning the roof gardens, I think a little over 6 months ago. The concept of a shadow license, I represent the landlord of these premises. They're operated by Caprice Chelsea Grill Limited as the Ivy chain. And the concept of a shadow license, in other words, a license that mirrors exactly the terms and conditions of the parent license, are enshrined in a case that I did 7 years ago called Extreme Oyster. Now, what I've done is I've written an advice, and I'm not sure whether it's been included with your papers. It's dated the 2nd of September. There it is. Look at that. How efficient. And essentially, I detail the background to the extreme oyster case and indicate the circumstances in which it's perfectly permissible for a landlord to apply for a shadow license in respect of the same set of premises which is already licensed. And I'm not suggesting for a moment that there's any concerns about the financial status of the operator, but it's a belt and braces operation, particularly in times such as these. So a prudent landlord is entitled to apply for a shadow license, says the High Court, in order to protect itself against instances where, for example, the tenant goes into liquidation. If that happens, then there's only a small limited window of 28 days in which you can apply as landlord for transfer of that license. And sometimes you get tenants who attempt to use the existing license as some form of hostage to prevent possession proceedings and to negotiate a settlement of their rent by refusing to consent to the transfer of the license. And so all the shadow license does is give back the power to a landlord in certain circumstances to step into the shoes of the operator and to take back the premises. That's all we're doing. And we're not attempting to extend the hours. You will have seen from many of the representations that there seems to be a misapprehension that in some way we're extending the hours, extending the operation, but we're not. It's exactly the same as it is already. Can I just say a little bit about Martin's Mews, because they're a family firm started by the grandfather Martin in well, it was 2 generations ago, and they own 90% of a portfolio which encompasses Chelsea. They own 20% of shop fronts and restaurants and residential in the King's Road, and they are a sensible and good and responsible landlord. I have to say, because I don't want to dismiss the concerns of the residents by suggesting that they've got nothing to do with an application for a shadow license. I have to say it came as some surprise to those who instruct me that there were concerns amongst the residents, and we're grateful that those concerns have been raised, because it allows us to go back to the operators and relay those concerns and ask what is going to be done about those concerns. Principally, they relate to the garden. They're not restricted in total to that. There is concerns about an event that took place in the garden, which was a charity event on the 19th of January, some 8 months ago. And there's also concern about the floral display, which you will have all seen on the outside of the premises, and suggestions that that in some way impedes the passage and repassage of pedestrians along the pavement, and also concerns about cars outside, and also concerns about noise. And we acknowledge that those are real concerns. And what we shall do at the end of this hearing is write a letter to Caprice Chelsea Grill Limited, indicating that we've had a hearing where these concerns were raised. And what we would like to do is effectively facilitate a dialogue, because I think one of the residents is concerned that in the past she raised these concerns, but that the operators did nothing about it. And we're unhappy that that has happened. And so what we shall do is facilitate a dialogue between those that operate and those that have taken the trouble to write in and make representations. So effectively, those are my applications. Thank you for taking them both together. As I say, I don't want you to think that these complaints have gone unheeded. Historically, there's been a license on this site for 250 years. They used to be called the Six Bells, And in the 1900s, they even had a bowling green in the garden. Clearly, times have moved on. They were Henry J. Beans, and then the Ivy took them over in 2015. And as far as we're aware, those are premises that are well run. But as I say, concerns have been noted. Sometimes it's suggested that an application for a shadow license is an attempt to circumvent review proceedings. That is the point about the shadow license at all. And if that is a concern, then the simple solution to that is to do, as I indicated in my advice, what Westminster does, and that if the parent license is brought in for review, then the shadow license is brought in for review as well. Now, I'm conscious of the fact that I've taken this really quickly, and I hope that I haven't misread the committee, and I hope that I can be forgiven for taking it quickly. I've got Mr. Stotesbury with me, who is able to answer any questions that I can't. But unless I can assist further, that really was all I was going to say.
Thank you. Thank you, Mr. Rankin. Thank you for that. That was very helpful. I'm just going to kick off just with one question, if I may, to you. I acknowledge your offer to facilitate a dialogue, and I think that is absolutely essential. And I'm very pleased to hear that the landlord is taking this seriously, because that is a sign of a good and prudent landlord. So thank you for that. And just in terms of getting everybody's details, the objectors' details. So maybe when we get onto the objectors, we can just confirm that they're happy to swap information backwards and forwards with you, and to make sure that the follow-up does indeed happen. So that would be very helpful if we could just confirm that when we get to the objectors.
Certainly.
Thank you. And I actually have one question for Ms. Stotesbury, if I may. Just if you could clarify about the garden use. I know this is separate to what we're actually looking at in terms of the shadow license, but there's just a bit of confusion in my mind about the garden use, because that did come up with one of the objectors. Thank you.
Well, but perhaps I can help on that. It's condition 10 of the license, which restricts use of the garden after 10 o'clock. So after 10 o'clock, the garden can't be used. And as far as we're aware, that is something which is adhered to. Although there have been occasions, as we understand it from the objections, where in the past a temporary events notice has been applied for and granted, to wit, the event on the 19th of January.
Understood. Thank you. And Ms. Williams, I see your hand is up, but we're going to come to you in a minute. So if I do note that, you will have your chance to ask questions in a moment. I'm just going to turn to my fellow committee members. If you could just turn your cameras on if you have any questions to ask Mr. Rankin and also the applicant.
If I could, on the same point of the garden, I note that general condition 10 says it shuts at 10 o'clock. But on page 2 of the application for 199 Kings Road, it says the current licence, which I think refers to the garden, sale by retail of alcohol both on and off the present premises to 12 o'clock, and also the provision of light refreshment is also to 12 o'clock. So I don't understand. I mean, is it 10 o'clock or 12 o'clock as far as the garden is concerned?
Yes, it's 10 o'clock. The page 2 indicates the general hours, and then those general hours are then qualified by the condition. So general hours, 12 o'clock. But if you have a condition, for example, condition 10, which further restricts the operation of the premises to a particular hour, the garden, then the garden must close at 10.
So that overrides. Okay, thank you very much, Mr. Rankin.
Thank you, Councillor Rossi. Councillor Wason, do you have any questions at this stage?
No questions from me. Thank you.
Thank you. So now...
Can I just come in again? I know Mr. Rankin has offered to take the complaints of the residents seriously, but there's quite a lot of complaints, it's all regarding noise and traffic and all the rest of it. So is there a way that the landlord can mitigate that and so that they are not disturbed in the same way?
I'm not suggesting that we should obviate all responsibility and say, well, that's down to the operator. But what I can say is this, that the dialogue that we shall enter into will centre on those complaints that have been raised. And we will want to know precisely what is proposed by the operator in terms of the floral display, for example, and whether that can be trimmed back, and the numbers of cars, for example, that are permitted to park outside the premises whilst waiting to pick up customers and dropping customers off. So that's something that we're going to centre on. But it's obviously it's not something that we can do. We can't have Mr. Stotesbury outside counting cars or trimming black floral displays. That's down to the Ivy.
Understood. Councillor Rossi, is that all right?
Yeah, that's fine. Thank you.
Okay, and
may I just, sorry.
Yeah, go ahead.
May I clarify one point? So in future, if a sub-license and a license is granted, when a complaint comes through, does it go to both the landlord and the operator? So you are aware of these complaints?
We will certainly be registered on your register of licensing premises as being the holders of a license in respect of 197 199 Kings Road. It would be prudent for the residents, now that they know who the entities are, the entity behind Ivy, the Ivy restaurant, it would be prudent if a contact number or a contact email address was given to those residents, so that when they make a complaint to the Ivy, we can be copied in on that, so that we know that there is a matter of concern for the residents that needs attending to.
That sounds great. Just so there is sort of clear accountability, so that in a future date, the landlord couldn't say, well, I wasn't aware of any of these complaints.
Precisely.
Now, both. Excellent. Perhaps the officers can take a note of that. Thank you.
Thank you, Councillor Royce, and thank you, Mr. Rankin. Because we are looking at two at the same time, if the committee were minded to grant these two individual shadow licenses, as everyone will be aware, there's quite a different set of conditions on 197 as opposed to 199. If we turn to on 197 on page 13, the conditions stop at condition 11, whereas if we turn on 199, the conditions go on to condition 22. And if the committee were minded to grant the shadow license, would the applicant be happy to add those 199 conditions, those onto 197?
I'd be unhappy for this reason, because one of the arguments that Guildford Borough Council put forward resisting my application for judicial review was that it's going to make enforceability very difficult. That argument it is answered by having a shadow license that mirrors exactly the license in respect of which an existing license exists. So we would prefer, please, just to avoid any confusion, that the conditions in relation to 197 that are imposed on my shadow license are identical to the 197 conditions at the moment, and that the conditions in relation to 199 are identical to the existing 199. That way, there is absolutely no confusion. Does that make sense?
Yes, that does make sense. I can understand that. And I suppose in reality, the conditions should be added to the original operator's license, which we are obviously not looking at today. So I do understand what you're saying. Thank you. So we're now going to ask, because our legal team may have something else to add to this before we get to them. So we're just going to ask the objectors now. If you have any questions, please, for the applicant. These are any questions. In a few minutes, you'll have a time to actually do your submission. But if you could just ask questions, please, now. Ms. Williams, shall we start with you, because you do have your hand up? Thank you.
Yes, thanks very much. I welcome in principle Mr. Rankin's suggestion that Martins, as a sensible, good, responsible landlord, will take these objections seriously. But it was slightly undercut by the rather flippant comments about Mr. Soapsbury standing outside counting cars and tripping back floral displays. These are actually issues of safety. If he had seen the number of people I've seen, elderly, many of them elderly and with prams, having to go into traffic, or cyclists very nearly being knocked off their bikes. It's not a question of trimming back floral displays. It's a large structure that obtrudes quite considerably onto a pavement at a point where we're all being encouraged to be socially distant. So I welcome these things in principle. I hope they will be taken seriously. And I will add to that, therefore, that dialogue, whilst sometimes helpful, we've all tried to have dialogue with the Ivy. One of the reasons many of us have had to make the objections in this regard is not because we don't understand shadow licenses, but because this is one of the few forums in which we've been able to express these concerns in a way that we hope the Ivy will now take seriously. So dialogue has been attempted in the past between residents and the Ivy, as you'll notice from the submissions. Many of us have tried to speak to the Ivy, and they have given lip service to this and then done nothing about it. So I guess what I want to understand from Mr. Rankin is, if the Ivy are going to, or rather, sorry, Martins are going to do their job as a sensible, good and responsible landlord, I just want something slightly more robust than we'll exchange numbers between the two of you and hope that you'll copy us in. Their job, surely as a landlord, actually particularly applying for a shadow license, which means that if the Ivy for some reason no longer own those premises, that they take seriously that their tenants are responsible in the way they behave as well. I appreciate they can't, do daily observance of that, but actually if they really are a sensible, good, responsible landlord, they'll be slightly more robust in following up these complaints than simply enabling dialogue, which has happened. So I think I would like to understand, I'm not really, the shadow license in and of itself doesn't bother me, except that I want to understand that Martins take seriously the behaviour of their tenants. And that's really the main reason I'm here. If I get suitable assurance, I don't particularly even need to make my submission, but I want to understand that Martins will be robust in the way that they pursue this with the Ivy. Mr. Rankin.
Thank you.
First of all, with your suggestion that
sorry, Mr. Rankin. Sorry, we can't hear you very clearly. Is your microphone?
My microphone is on.
That's better. That's better. Thank you.
In relation to the flippancy, I wasn't intending to be flippant at all. What I was attempting to do was to identify the different roles between a landlord and the tenant. And if I gave an example which appeared flippant to you, Miss Williams, then I apologise. It's not just a question of exchanging numbers. We, as landlords, understand that you have real concerns, and we understand now that those concerns which were articulated in the past to the Ivy have only been given lip service, and that concerns us. So when I say it's an exchange of contact and email numbers, that's the start. It then goes on to the dialogue stage where we sit around a table and you identify as a resident the concern that you have. We, as a landlord, then reiterate those concerns to the operator, and we ask the operator what they're going to do about it. That's the process, but it isn't just a question of giving you our number. It's rather more involved than that, and we will be rather more involved than that. Does that answer what you raised?
That does answer what we raised. I think I would, I'd like to see that set out in slightly more detail, but as long as you're taking this seriously as a landlord, that is my main issue. As I say, I understand the legal process of a shadow license, but unfortunately, given the way that the Ivy have dealt with this has been the only forum, and I consulted the council about this, in which we've been able to address this more robustly. So that's, and as I say, these aren't just issues of noise, although those issues are serious ones. They are issues of safety and a complete disregard, really, both for local residents and the local area, and particularly over the last few months where, people have had different safety concerns. The Ivy seems to have I've tried a number of times gently to speak to them about this. I have no issue with having them there. I moved into a block of flats with a bar and restaurant underneath it. I have no issue with that. What I do have an issue with is them not taking this seriously. So as long as that's something that Martins are going to do, that's absolutely fine.
Yes. Yes.
Thank you, Ms. Williams. And also, you mentioned about the floral display. I'm going to make a note to chase it up with our highways team, which is obviously a separate team from this committee here, which is licensing, because we do require clear widths of pavement for all pedestrian safety. So I've made a note for our highways team just to go there and check as well from a council point of view.
Thank you.
Thank you. And Ms. Partridge, do you have any questions? I see your hand is up. Do you have any questions for the applicant?
Yes, I do. First of all, just a further point on the offer from Mr. Rankin to facilitate the dialogue between the landlord and the residents. Like Ms. Williams, I would welcome that. However, I do share her concerns as well on the robustness of the approach for that. For reference, my husband and I, who I live here with in the flat, have had dialogue with the Ivy and the landlord regarding a significant noise issue about the noise from the ventilator fan from the Ivy, which is outside our bedroom window. The representative of the landlord did not take our issue seriously at the time of visiting. Both the landlord and the Ivy were also quite reluctant and slow to respond and manage the issue. So I am hesitant to believe the difference it will make. In addition, around this point, we've liaised with the Ivy directly on an issue, another noise issue of furniture being scraped down the delivery corridor every evening. And that's a noise which reverberates up into our flat at a quite high level. Numerous times they told us they would stop it happening, but they didn't. It is stopped at the moment because when they have floral displays, there are no tables outside to be dragged in each evening. Regarding the parking issues, I'd also like to add observation that many cars ignore the parking restrictions that are outside. So I'd welcome you speaking to your other council members about that. Cars and vans receive tickets, but they're not moved on.
Ms. Partridge, sorry, could I interrupt just for one moment? Do you have a specific question to the applicant? Because we'll come on to your... Thank you.
Sure. I have a question for him, which is that whilst it's understood about the garden closing at 10 p.m, what I'd like to know is how you will stop noise coming through the walls, as I've described some of the issues after that time. These are old buildings and the transfer of noise is an issue, which I will come on to speak more about in my presentation. So how will you stop the noise coming up through the walls at the times after 10 p.m?
That obviously will form part of the dialogue that we shall have with you and the operators. And if it needs the operators to hire acousticians to take readings in your premises to see where the noise escape is coming from and how severe the noise escape is, then that will have to be done.
Okay.
These are things that the operator must attend to. I'm not washing my hands of it at all. I'm indicating that if those are problems, then they must be attended to, and we shall assist you in making sure that that happens.
Okay, thank you. We appreciate that.
Thank you. And Ms. Partridge, we'll come back to you, obviously, with your full submission in a few moments, because there's a few things I'd like to pick up there as well, which I'm sure you'll highlight further. Licensing team, have you got any questions for the applicant, please, Mr. Phelan?
Nothing at the moment, Chair.
Thank you. Legal team, any questions for the applicant, please?
Not at present, Chair.
Thank you. So we're now going to move on to the objectors case, please. So we have Ms. Williams and Ms. Partridge. If you could please both present your objections. You have up to a maximum of 10 minutes each, and then we will all ask you questions if that's okay. Thank you. So Ms. Williams, would you like to go first?
Yeah, I think I've made most of my points. The only thing I would just add is that the only substantive objection I have is to granting a shadow license to a landlord who doesn't take seriously the actions of their tenants. So this talk of dialogue, actually, Ms. Partridge picked up something very helpful there, which is that the Ivy have all of our objections to hand. It seems to be a much more sensible process that Martins take seriously their responsibility responsibility as a landlord and ask, as Mr. Rankin says they might do, the IB what exactly they're going to do about them and have put in some accountability measures, and then come back to us. And if there are questions, then as well as things like to council and to the landlord. And that would be my only objection, I guess, is just that I have otherwise no issue with the shadow license, but I do worry about granting a shadow license to a landlord that doesn't take their responsibility seriously. So, as I say, as long as and I don't think the process is more conversation between residents and the IB. We've done that. It hasn't worked. It's now got to a stage where I think it's escalated, whereby the landlord needs to deal with them, ask them how they're going to deal with these objections, which are clearly set out. I don't really want to repeat them again. Get some sense of the actions which the IB are going to follow, and then they bring those back to us. So that would be my suggestion for the next stages. And if the landlord is reluctant to be responsible in this regard, that would be the only query I would throw up in terms of potentially whether this is something that it would be prudent for the council to grant. Otherwise, I have no issues.
Thank you very much. That was very succinct and helpful. And before we ask you any questions, I'd just like to hear Ms. Partridge's case as well, please, and then we'll ask you both questions together, if that's okay. Thank you. So, Ms. Partridge.
Sure. So I guess I'd start by saying I understand the role of the shadow licence and the need for Martin's Properties to have that and being prudent in the current circumstances. However, my concern is that the terms of the current licence that are registered, that this is a shadow of, do result in noise disturbance. And what I am asking for is for the shadow licence to be limited in the hours which it applies to minimise that disturbance in the future, should the current tenant, the IB, leave. So as I started touching on, the nature of the building design, noise from 197 to 199 does reverberate up into the flats, which means that there is disturbance to the residents as a result of a business operating there. So I believe that the hours at which the business is allowed to operate is key to the discussion for me. We've touched on, and you've got examples from all the submissions of the type of noise disturbance, being music from in the venue, noise from the garden, movement of deliveries and furniture, as well as the noise rising from the street. Like Ms. Williams, I accept that we live in a city and accept that there will be a certain level of noise, and particularly in the daytime. However, I don't believe it's acceptable to provide a licence which means that residents are disturbed beyond 10 p.m, which affects their sleep. In addition, the provision of a licence without the knowledge of the specific business is concerning to me. So particularly on this point around the off-premise licence, around the sale of alcohol, I don't believe that IV fully utilises that, but the potential that's offered by the licence could result in more noise impact if it was actually fully utilised by people coming to shop for alcohol later, particularly later in the evening. So what I'm really asking the committee to consider is if there could be a reduction in the hours of the shadow licence to limit noise disturbance for residents in the future should the current tenant leave the property.
Thank you, Ms. Partridge. That's understood. Thank you very much. I'm just going to kick off with a couple of questions. So this is, I suppose, for you, Ms. Partridge. So on, let me just get this, on the 197 licence, there has been some complaints on page 35, Appendix F. There have been complaints sent in to the council. So as a way of helping residents, if complaints are received to our noise and nuisance team, then they are kept as a record. And because we always want to encourage responsible operators, we want the IV to listen to you. And I'm sorry, it sounds as if they have not been taking your complaints seriously. And as a council, we can, our noise and nuisance team can help this. Obviously, that's what it's there for. But we need to have records of this. So I think it's great that you are speaking direct to the operator, and I fully acknowledge that, and that's fantastic, and you're trying to kind of do it sensibly. But unless we have a record in the noise and nuisance team of all these incidences, the ones we have here, they're construction noise, COVID restrictions, and the structure. But what you are saying in terms of the ventilation noise, the lack of acoustic separation between the premises, none of that is listed here. So if I could kind of form this as a kind of a question, to saying, have you contacted the council noise and nuisance team? Is my question to you.
And now I'm digging in my memory. I can't remember if we did, and it's interesting coming into this process. I hear what you're saying, and seeing the submissions, it made me realise that we need to be doing that and giving you the record of it. We had, as you said, tried to deal directly with the Ivy because we felt that they were the people who could make a difference. We will in future submit issues through this. We do have a record of emails between us and the Ivy of all the instances. So I do have a record of when we were tracking the noise issues of deliveries, scraping tables, etc. But it's not formally on your website.
Okay, thank you for that. And again, as a committee, we always try to encourage objectors and operators to all kind of communicate. So I think it is great you are doing that step. But if you need further backup, that's what the council really is here for. So thank you for that. I have no further questions. Councillor Rossi, do you have any questions for either Ms Williams or Ms Partridge?
Yeah, one question for both the objectors is, how often are they disturbed? We don't have a record here. So in a week, is it every night? Is it just at the weekends? How often are you actually disturbed by the operations of the Ivy? For either or both?
Sorry, I'll go first. It's been obviously a weird period over the throughout lockdown, because it's been sort of tricky to work out. But prior to that, certainly in the summers, it would be reasonably regular. I think Ms Partridge is in a slightly different position from me in that she and her husband live in an area where some of the noise carries a bit more. I made the point about that special events notice, the temporary events notice that they got, where my issue with the disturbance is that when in the past I've gone and made a representation, like on that special events notice, they haven't taken it seriously. So I completely understand that from time to time they're making more noise than they realise, and that's where it's simple just to pop next door. So it's less to do for me with frequency. It might be a different situation for Ms Partridge, but certainly the other issues I made, which were around the safety issue, the social distancing issue, those things have been going on pretty much the last few months. So it's a slightly odd question right now, just because obviously they weren't in operation throughout much of lockdown. It happens reasonably frequently for me, but the level of the noise disturbance up until 10 o'clock, I acknowledge that's something that they do. It's just times when it's been more. So for instance, with that the huge loud noise of that PA system, and that I went to ask them not to turn it off, even just to say, please, could you turn it down so you can hear it in the marquee, but we don't have to hear it in our houses, and received, again, lip service. So for me, it's not so much to do with the frequency of the noise much of the time, as just to do with their refusal to actually do as they're asked, very politely. I hope I asked very politely. In terms of the other issues about the safety and the traffic, that has been a continuous issue for the last few months.
Okay.
I would support what Ms Williams has said, in that the sort of safety in traffic and the noise associated with that comes through is ongoing. I think with the issue, the music coming up, and that's more irregular. I can start tracking it, but sort of certainly a couple of nights a week there is music noise coming up. I think the key thing for us is the issue of that type of noise coming up after 10 p.m. It's the fact that the license, if it was used in full as the shadow license would allow for the Ivy or another entity who we don't know who we might be talking about now, but in the future would have basically the right to be making noise that could affect us because of the way it comes up into the property after 10 p.m. It's the sort of that cutoff that's my concern about in the future, what this license as a shadow license could open up
Could I ask just one supplementary question then,
Yes.
Councillor McVeigh? Yeah, you go on about 10 p.m. as being the cut-off point. So I understand very well why the garden should be shut at 10 o'clock, but a restaurant will normally go on later than that. I mean, are you suggesting that the restaurant be shut at 10 and that all noise stops at 10?
I'm not suggesting it should be shut. I'm suggesting that I think it's unfair for residents to be disturbed after 10 p.m. And I guess I'm sort of associating that to the issue of the way the noise comes up into, and I am, as Ms. Williams pointed out, right on the edge of the ivy, so we are particularly affected by that. So I guess it's that, you know, my feeling is that if the licence allows them to operate after 10 p.m, there is always the sort of noise coming up at that point, and it's an issue we never used to have.
Thank you, Councillor Rossi. Thank you, Ms. Partridge. I must also just remind everyone this is not a review of the operator's licence. But I understand what Ms. Partridge is saying about starting somewhere, so I do accept that. Mr. Rankin, do you have any questions, please, for the objectors? Oh, sorry, Mr. Wason, Councillor Wason. Sorry, do you have any questions for the objectors?
No questions from me.
Thank you. So now we move on to the applicant. Do you have any questions, please, for the objectors?
Well, it's not a question, but it answers a point that Mrs. Partridge raised in response to her suggesting that the hours of my application be cut back and that we were denied the ability, for example, to have off sales. That would result in a shadow license which doesn't mirror the parent license, which is exactly what the High Court sought to avoid. The whole point about a shadow license is that it mirrors the parent license. But apart from that, I have no questions.
Thank you very much. Any questions, please, from our licensing officers to the...
No, thank you, Chair.
Thank you. And any questions, please, from our legal team to the objectors?
Not to the objectors. I've got a question to the applicant when you're ready for that.
Okay, I think we're going to move on to that. So, Lindsay, yes, please. Sorry, would you like
Thank
to?
You. Thank you. Mr. Rankin, I just wanted to ask if the committee were minded to grant the shadow licences for both applications, would you be prepared to accept a condition saying on both licences, this premise licence shall have no effect until such time as the existing licence for 197 and 199 Kings Road have been surrendered? So to ensure they don't come into effect until concurrently.
I'm going to have to take instructions from Mr. Mayline on that. Thomas, come in. Thomas?
Yes, I'm here. Can you see me?
No, we can't see you.
Can you hear me?
We can see and hear you now.
Ah, excellent. Yes, I can confirm that we'd be happy to accept that condition.
Thank you.
Thank you.
Thank you. And just one more question, if you don't mind, Chair. I know that you've touched on transposing conditions from 199 to 197. And I know Mr. Rankin said he'd prefer to keep it as is, but there is no reason why the council could not have similar conditions on 197 as 199. For example, CCTV, because I'm sure the CCTV would cover both premises in any event, or deliveries. I mean, the issues would be the same. I mean, in theory, would you have no objection to us doing that? Although ideally you wouldn't like it.
Ideally, I wouldn't like it because it's going to create confusion between the parent license and the shadow license. And when is one, when do the conditions apply and when do they not apply? It's so much simpler and so much more elegant, please, if you just grant the licenses in exactly the same terms. If at a future date, and that seems a possibility, the residents bring the parent license in for review and the shadow license is brought in as well, then at that stage we can look at the question of whether additional conditions need to be loaded onto the licenses. But the time for doing that isn't now. The time for granting a shadow license in identical terms is now. This isn't, as already has been indicated.
Sorry, may I just interject there? But if the shadow license doesn't come into effect until the end of the operator's license, would that not make a difference?
It doesn't really make a difference, other than the High Court is careful to indicate that a shadow license must mirror the parent license. But that's all I'm asking you to do, is just to do what the High Court suggests. And at a later date, we need to tinker with conditions, then we will, but not at this time.
Thank you. That's all I have to ask.
Thank you, Lindsay. I've just got a question along those same lines as well. So if there was a review of the parent stroke operator license, at the same time, would the shadow license also be in review as well?
It doesn't, by operation of law, automatically bring the shadow license in for review as well. But now that the responsible authorities and the residents know that there will be, if you granted, 2 shadow licenses in respect of 197 and 199, then they too should be brought in for review, and then the whole shooting match dealt with at the same time.
And is that a standard procedure, or does that have to be noted somewhere, or what is the legality, the legal process for that?
The legal process is one simply puts in an application to review not only the parent license, but also the shadow license. That is all laid down in statute, the review procedure.
Understood.
It may be at another time, because I've included in my advice the way that Westminster approaches shadow licenses, and indicated that they, as a matter of course, would think it prudent that the shadow license is brought in for review if the parent license is brought in for review. It may be that if your statement of licensing policy is going to be reviewed itself in the near future, that you may want to perhaps add a couple of paragraphs about shadow licenses.
Thank you for that. And just in terms of what Lindsay Lemasuria was talking about, the surrendering of the license, should the wording be slightly altered? Because sometimes, as we know, tenants may not surrender the license, and it may be forced on them through various different methods or ways.
Councillor, may I suggest perhaps we add the words, or if the freeholder has forfeit the leaseholder's tenancy, or words along those lines, if that's acceptable to the applicant?
I don't need to take instructions, but I ought to formally. Thomas, that must be sensible, isn't it?
Yes, that's all agreed. Thank you.
Thank you.
Okay, that is, of course, if the committee is minded to grant the shadow licenses. So any questions now, please? I'm going to turn. Lindsay, do you have any more questions?
I can't think of any more questions. I mean, obviously there was issues of like the smoking and the footway obstruction, which you could possibly add as conditions, but obviously Mr. Rankin has made it clear he just wants duplicate conditions, but you could consider conditions about not obstructing the footway and patrons only smoking in designated areas. They're the only other things I thought of.
Thank you. I think these points need to be taken up with the environmental health and the highways team.
Okay.
Thank you. And any questions, please, from our licensing team, Mr. Phelan?
Nothing from me, Chair. Thank you.
Yeah. And now our governance officers, do you have anything you wish to raise that has been brought up during the hearing?
Nothing from me, Chair.
Thank you. Thank you. So we have now reached the end of this meeting. The committee now has, can I just check that there are a couple of hands raised? Are they old hands that have been raised? is anybody participating in this meeting got a hand raised and they wish to say anything now? No. Right. Thank you. Just checking before we close this meeting, because the committee now has all the information and we are going to retire to a private session to make our decision. We will not announce a decision today. Instead, the hearing on this application will be closed and the live broadcast will shortly end. And a summary of the decision will be sent to the parties within 5 working days of today's hearing, and a full decision will follow as soon as possible thereafter. So thank you all for attending, and this hearing is now closed. Thank you.